brings us to the end of our class on environmental issues. At the beginning, we talked about various environmental laws and we covered elements of common law. We also discussed the core state and federal environmental statutes. The primary legal concepts we addressed were nuisance, trespass, and negligence. Nuisance refers to something that damages both the environment and people, and it has to be caused by human actions. Public nuisance affects the whole community, while a private nuisance affects an owner's ability to use and enjoy their property. Trespass is when something, like pollution, physically invades a person's land and prevents the person from using the land. This does not apply when things like noise, dust, or fumes cross into a person's property. Those are better examples of a nuisance. For trespass, something more tangible like water or dirt would need to cross the property line. Negligence involves harm being caused by another party's carelessness or inattention. The concept relies on the reasonable person doctrine. A person acts negligently if they do something a reasonable person wouldn't do, or fails to do something a reasonable person would. The foundation of federal environmental law comes from the provisions of the Clean Water Act, the Clean Air Act, CERCLA, which is also commonly referred to as the Superfund Act, the National Environmental Policy Act, the Safe Drinking Water Act, and the Pollution Prevention Act. Michigan's primary source for environmental law is the Natural Resources and Environmental Protection Act, or the NREPA. We looked at different types of pollution and waste, and which apply to residential and commercial settings. The quality of water and the level of pollution in water is governed on a federal level under the Clean Water Act. In Michigan, water pollution is addressed in Part 31 of the NREPA. Solid waste is federally managed through the Solid Waste Disposal Act. Part 115 of the NREPA contains Michigan's regulations on solid waste. We discussed types of hazardous waste that might be generated in a residential setting, along with the obligations homeowners will have in dealing with them. Hazardous waste is a special category of waste products and includes such things as scrap metal, used oil and paint, wastewater, and contaminated soil. Hazardous wastes are covered at a federal level by the Resource Conservation and Recovery Act, and at a state level by Part 111 of the NREPA. Michigan regulations define hazardous waste based on factors like ignitability, or the tendency for something to light on fire, corrosivity, relating to a liquid and their pH value, reactivity, referring to the instability of a substance and likelihood of an explosion, and toxicity, the measure of danger a substance poses to animal and plant life. There's also the category of common waste products which, when managed in a specific way, are not considered to be hazardous waste. These are called universal wastes. These can include antifreeze, batteries, some pesticides, and certain items containing mercury, such as thermostats and barometers. Then we went into the NREPA in greater detail. Part of this segment focused on Part 17, called the Michigan Environmental Protection Act, or the MEPA. We looked at how hazardous wastes can be managed and the responsibilities of a landowner in dealing with existing contamination on properties they purchase. Fortunately, the state of Michigan offers an opportunity for new buyers to protect themselves through the use of baseline environmental assessments. We cover the requirements entailed in a buyer using this process to protect themselves. As we neared the end of the segment, we looked at the impacts of contamination on market value, and we explored the opportunities that contaminated properties present for redevelopment and investment for the future. Pollution and contamination isn't something anyone expects to have to correct or contend with when dealing with a property. It can and does happen, though, for a number of reasons. If this occurs while you're working with a client, it's likely they'll turn to you for advice, so be prepared. And being prepared means having an understanding of environmental law both on the federal and the state level. In the last segment of our class, we'll talk about important concepts, terms, and regulations that we haven't gotten to yet. Thank you for choosing At Your Pace Online.